Hello, welcome, Employment Law Show. This is the show. You'll learn so much about your employment law rights and how to navigate those each week on the show. John Scholes here alongside Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed employment law firm across the country. How about that? You want to reach out anytime, we'll throw it up on the screen and I'll give it to you throughout the show. 1-855-821-5900, help@employmentlawyer.ca. And if you want to tune into one of our radio shows across the country, simply go to employmentlawyer.ca. There's a drop-down menu there as well. I think it's the media tab. You can check that out and have a look. So on the show today, put on a performance improvement plan. What's that all about? We will cover that and dig into what is a performance improvement plan in just a bit. That's some phone calls from the radio show. But first, Lior, we always start off with the week that was. It's Lior's choice this week. So have at her.
Wow, the excitement is palatable.
My cup runneth over.
I don't know how we can contain the excitement. Well, but in seriousness, I know that there's a lot of questions, issues that people are dealing with these days with their job security, their ability to continue working, supporting their family. That's why what we talk about on the show every week is so important. You know, jobs are serious. We work, oftentimes, if we're lucky, we can work because we just enjoy it. Most of the times we work because we need to. We have obligations. So we need to understand our rights, how we can continue working and supporting our family. So on the show, we'll touch on many things: losing your job. We'll touch on vaccinations. We'll touch on constructive dismissal. We'll touch on harassment. You name it, things that are important. We're going to touch on it every week. You can learn so much, so I'm glad you're here with us. And if something that we say reminds you of an issue you're dealing with or raises additional questions about an issue that you're currently facing, no problem. We're going to give you my phone number, my email address throughout the show so we can connect privately and have that discussion. So your ability to get answers doesn't just end when this show ends. There's plenty of opportunity to do that, and you have to do it. But to get us started, week that was, let's talk about a couple of situations that came, or at least one that came across my desk over the past week. I spoke with a lady who had been off because of a serious medical condition, John, for about a year now. She's receiving treatment. Her doctor supports her. No one is debating that she has a serious medical condition. That's not controversial. So she's at home getting treatment, getting better, hoping that at some point in the not too distant future she'll go back to work. And she gets an email from her employer saying, well, we considered your situation, spoke to HR, you've been off now for a year, and because of that, I think we have to end the relationship, so we're going to wish you all the best. She emailed them. I said, well, am I going to get any compensation, any severance? They said, no, because you've been off so long, we don't have to pay you anything. But hey, if you ever are able to come back to work, you can feel free to reapply for a job and we'll consider it. That's when she calls me. John is here. You can't see him smirking, and because he knows what I'm about to say. I'm about to come down pretty hard on this employer, as I should. And the reason for that is she can be off as long as she needs to be. She cannot be let go because she's sick. She cannot be let go because she's been off for a year. She has her doctor's support, meaning there's no clock ticking. Whether it's a month or a year or longer, she can be off work. That does not allow her employer to end the relationship. That does not allow her employer not to pay her compensation if she is let go. Now, of course, there would be a point in the future if she's gone for that long and there's no hope for her to come back to work, that yes, the employer can say enough is enough. That's not even close to being the case here. So there's potentially a human rights violation here. They're letting her go when she's on a disability leave. There's certainly a wrongful dismissal because they owe her severance either way. And for her, over 20 years of employment, she could be looking at 2 years severance plus human rights damages. So it's an important reminder right there for employers and employees. If you're sick, have your doctor's note, have your doctor's support. If you are at home trying to get better, you cannot be let go, even if you've been off for a while. As long as you're working on getting better and there's some hope that at some point you may be able to come back to work, even on modified duties, modified hours, your employer cannot say enough is enough, cannot let you go. There's significant repercussions if they do that.
Do you need to check in once in a while? I mean, she's been off for a year, looks like potentially longer, but do you have to give your employer the courtesy of checking back every so often, weeks, months, and say, hey, still off, working on coming back, but I'm still off?
I like that. There's no law that says you have to, but as a practical matter, is it going to help to do that? Yes, it can and it will. So what do I like to say? If you're going to be off for a long time, hey, every couple of months, send a quick note, a text message saying, still following doctor treatment, we'll update you, just so that they know you're there, so that they know that you haven't forgotten about them, that you're planning at some point on coming back to work. Very good idea to do that. Again, you don't have to, but I think it's a good idea.
Obviously, you didn't mention what was wrong with this lady in this phone call you had, but let's bounce that over to the employer for a sec. What are they allowed to ask and not ask for someone who is off work?
These days, John, I'm seeing a lot of employers, when they have employees that are providing a doctor's note, wanting to know what is your diagnosis, what is your medical condition, what treatment are you getting, what specialists are you seeing? No, no, no. Your employer does not have a right to demand this personal and private information. They're not allowed to know what your diagnosis is. Not allowed, it doesn't matter. All that matters is whether you're able to work, whether it's because of bad back, depression, or an immunocompromised condition, it doesn't matter. If you can't work and your doctor says that, that's what's needed. So your employer can't know diagnosis, they're allowed to know prognosis. How long are you going to be off work potentially? What kind of accommodation you may need? That's it. You're well within your rights, and in fact, you should say no when your employer wants to know the specifics of your medical condition.
This sound familiar to you or any colleague you're associated with? Call Lior and just get some information, right? 1-855-821-5900. Website, always an option, employmentlawyer.ca, which is where we go to find a radio show. And our first call from one of our radio shows, Lior, is coming up right now here.
Family member of mine was just recently given a written working notice after working full-time for 37 years with the company. In this time, since she's gotten the notice till she's being paid, but at the end of that, basically they just pay out any unused vacation for the year. There's no sort of severance. There was some issues with a bit of ageism in the workplace too, so just kind of looking at options.
Approximately how many months' notice did she receive?
About 8, 9.
Okay.
For 37 years. Wow.
You don't think that's good enough, John?
Congratulations, by the way. Well done. 37 years.
It is impressive. Yeah. It is quite impressive. So let's start with this idea of notice, advance notice of termination. You hear me talk on the show a lot about severance.
Yep.
When we say severance, we're talking about the amount of compensation that you're owed if you lost your job. One way an employer can avoid paying that is, instead of paying severance, they can give the employee the equivalent in advance notice of termination. So if an employee is owed 12 months severance, the employer can say, we're giving you 12 months advance notice of your termination. So for 12 months, you're going to continue working, and 12 months from now, you're going to be let go. As long as the employer gives sufficient notice, the right amount of notice, they may not have to pay any severance at the end of employment. Now, if the employer doesn't give enough notice, they give some notice but not enough, they're going to have to make it up at the end of the notice by way of severance, by way of payment. So the real question in this situation, this lady after 37 years was receiving 8 months advance notice. Is 8 months enough? It's not enough. John here spoiled it by shaking his hand. It's not. But let's be more specific than that. Let's go to pocketemploymentlawyer.ca. Let's plug in the information in there. You'll see how easy it is to use the severance calculator tool at pocketemploymentlawyer.ca. And let's see what that gives us. So 37 years of age, 37 years of service, my gosh. So likely a bit older, probably in her 60s, was given 8 months advance notice. You can see on the screen that what she was really owed is up to 24 months, okay? 24 months. So if she's owed 24 months and she's received 8 months, well, the difference, my math, I think is correct, is 16 months. So at the end of employment, her employer still has to pay her for another 16 months. So the fact that they're not planning on doing that, that's a wrongful dismissal. That's not difficult to resolve. So for you as well, if you've received advance notice of the termination of your employment, you can always go to pocketemploymentlawyer.ca to find out if that's sufficient notice and how much more severance you're going to be owed at the end of employment.
Want to ask more questions anytime? Terminationquestions.com. That's the website you go to. We'll get to one from Melissa. And Melissa says, 2 weeks ago, I was brought into a meeting where I met my replacement and told that I was being demoted from manager to alleviate my burden. I was completely blindsided and embarrassed by this. What should I do?
So we're going to demote you, but it's for you, really. You'll thank us later. Oh, my gosh. With friends like that, who needs enemies,
No
right?
kidding.
So let's be very clear. Your employer does not have a right to demote you. Okay, a demotion is a big deal because it's not just about money. It's about your stature in the workplace, your prestige, the way you're viewed by your workers. So if you're in a managerial role and tomorrow you're demoted to a non-managerial role, well, how are you going to be viewed in the workplace? How are you going to be able to continue working with the same colleagues? You're probably not going to be comfortable doing that. And it's because of that that the law says, no, that's a constructive dismissal. You don't have to continue in a situation where you've been demoted. You don't have to face your colleagues and try to explain what happened. And it doesn't matter if the company is thinking that they're doing this for you. So if your company wants to do that and you say, no, I'm not agreeing to that, that's not what I want, if they push ahead and do it anyway, you can treat that as a termination. That's a constructive dismissal, and you're going to be owed severance. And for many people, I think that's going to be the best thing to do if there's a demotion, because number one, it avoids that embarrassment in the workplace. And number two, and just as important, you're not going to then give your employer the right to do it again. If you accept one demotion, you've given them the right to demote you again and again, a bad precedent to set.
The performance improvement plan, ever been on one? Not sure what it is. We'll discuss that after a short break, which we'll take right now. You'll want to write down the phone number, by the way, 1-855-821-5900. Email address anytime is help@employmentlawyer.ca. We'll continue. Stick around. This is the Employment Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes, of course, Lior Samfiru. You want to reach out anytime, employmentlawyer.ca. You'll find links to our long-running radio shows across the country as well. They're an hour long. You can listen to those and actually call in and get some information, some questions answered as well. But the performance improvement plan, let's dig down into this a little. What is a PIP, a performance improvement plan?
Yeah, a PIP, a performance improvement plan. A performance improvement plan is the idea behind it, at least, is that wherever that we have an employee that may not be up to snuff, may not be doing a good job, but where the employer thinks that there's ways to improve it, it's a plan, it's a program that the employer puts in place to improve performance, to set milestones, and to provide the assistance that the employee needs to get better. So keep in mind, a performance improvement plan is different than a bad performance review.
Right.
Bad performance review says you're doing a bad job. A performance improvement plan says, here's what we need to do together, employee and employer, in order to improve that performance and to get you to the place that we all want you to be. Now, it's never a pleasant situation or never a pleasant thing to hear that you've been put on a performance improvement plan. You'd rather hear you won the performance award. But we have to talk about how that can happen, when is it possible to be put on a performance improvement plan, and what to do if you're on it.
Well, that kind of brings about the next question. That is, what if the employee disagrees or feels sheepish about being on this plan? Is there anything they could do, or what should they do?
So oftentimes, a performance improvement plan is a step towards a termination for cause. In other words, an employer wants to be able to show, listen, we've tried to help this employee, we've tried to improve their performance, nothing happened, so now we may be able to terminate them for cause. So in a situation where you disagree with a performance improvement plan, you don't think you should be on it, you don't think you did anything wrong, or that the expectations that the company set are not reasonable, you have to say something about it. You have to say something about it, and I say, but I mean write. You have to put it in writing. The worst thing that can happen if you disagree with the performance improvement plan is you just sign off and you move on with your day, because that's the same as agreeing. That's the same as saying, yeah, this is right. I made a mistake. I'm going to now abide by this plan. So if you don't agree with it, if you think the information is not accurate, if you think that whatever the expectations are unreasonable, you're not going to meet them, they're not giving you enough tools or resources to support you to meet those expectations, say so. Make sure it's in writing. You don't need your employer to agree. Frankly, you don't even need your employer to acknowledge. But just by virtue of sending that response, you're going to make it that much more difficult, several times more difficult, to even consider terminating you for cause. So the key, if you disagree with a performance improvement plan, say so in writing, politely. I'm not saying you send emails accusing employers of all kinds of bad things, but responding in writing is key.
The flip side of that is this, though. What happens if the employee, fails to stand up and protest an unreasonable performance improvement? What happens then?
So silence is the same as acceptance. So if you've been put on a performance improvement plan and you don't do anything about it, you don't say anything about it other than, well, put your head down and hope for the best, it's as if you say, everything in this 3-page document is correct. Now, if it's correct and your performance doesn't get to the level of that document, the employer can, at that point, hold that against you. You agreed that your performance was not good. Right. You agreed that this performance improvement plan was reasonable, and that's what's needed to help you improve performance. Despite your agreement, you didn't do it. Well, now we can let you go for cause. That's why silence is no good. Now, if you agree with it, if you think it's legitimate, it's fair, it's accurate, perfectly fine. Do your best, continue working, and that's okay. But if you don't agree with it, or even portions of it, or there's something there that's not fair or reasonable, say so in writing to protect yourself.
What if the employee, sits back and thinks, oh, wait, I got an idea. This performance improvement plan's coming down the pike. I'm going to go on a medical leave.
Yeah, so I know how to deal with my workplace problem. I just won't be there when they tell me about it. No. We're laughing. I know it's not even funny. The reality is it doesn't solve anything. Going on a leave of absence to avoid being there to get bad news doesn't do anything. It just delays the bad news, and it probably makes your employer think even less of you in that situation. So I'm not a supporter of that. Not a good idea. Best to deal with it head on, to respond in writing. Now, it's okay, by the way, to sign the performance improvement plan to acknowledge that you've received it. Right. So yes, please sign here acknowledging that you've received a copy. That's perfectly fine. You did receive it. You're not going to deny receiving it. If you don't agree with it, you can't sign acknowledging that it's correct and accurate. In most cases, the only thing your employer is going to ask you to acknowledge is to sign that you've received it. So what do? You sign that you've received it, you go back home, you think about what you want to say, how to compose that email, send that email at that point, that's fine. But going off on a medical leave is not going to do anything.
If someone fails the performance improvement plan that they've been put on by their employer, is that enough for the employer to say, oh, cause, you're done?
So, let me answer this by explaining what cause is. A termination for cause is a situation where the employee did something so bad, so terrible, that it's just not possible to continue employing them. That means that the employer can let the employee go for cause without any compensation. That is very, very difficult to do. It's the capital punishment of the employment relationship. It's reserved for the worst offenders. So, bottom line is, even if your performance is lacking, even if you're not quite where you want to be or where the company wants you to be, even if you've been put on a performance improvement plan, does not mean that you can be let go for cause. To be let go for cause, the company would either have to show that you're deliberately not working hard, or potentially simply show that they've tried to work with you, they've given you warnings, and there's nothing else. There's just no way to improve your performance. In most cases, when the company terminates for cause, they do that well before they should. That's a wrongful dismissal. Chances are, in the vast majority of cases, performance improvement plan or not, if you've been let go for performance reasons, certainly it's not cause.
At what stage in this whole process do they say, you know what, I've got to call you and figure this out?
If you feel that your employer is trying to build the case against you to potentially try to let you go for cause, it's a good idea that we speak. So we can talk how do we respond, how we build up our own case in that situation. Very important to do that if you think that's being built against you. Certainly, if the company lets you go for performance reasons, they say, well, you are on a performance improvement plan, you didn't improve, now we're letting you go. Definitely that's going to be a situation you pick up the phone and call me. Chances are that's a wrongful dismissal. Chances are you're going to be owed significant severance.
As always, any of this is confusing. You need more information about the performance improvement plan or anything for that matter, simply make that phone call, 1-855-821-5900. We'll take another phone call of a different sort, this one from our radio show. We'll get to that right now.
So my question is, I was employed for commission sales for about 7.5 years. Amidst of the pandemic, I was terminated along with a few other people. I was given severance, the minimum. We were never paid vacation pay when we were there. And when I brought it up during my termination, I was told that it was part of my commission.
Part of the commission. Wow, that's great. Well, now think about it this way. What a solution. An employer can just say, oh, we're not paying you vacation pay, it's just part of your salary. Wow. I can't believe employers are not doing that. Well, I actually can believe employers are not doing that because it's illegal. Okay? So vacation pay is above and beyond your commission, above and beyond your salary. So vacation pay is calculated on top of that. So no, that is a improper way. If your employer doesn't actually pay you vacation pay calculated as a percentage, depending on how many weeks vacation, 4%, 5, 6%, then no, they're breaking the law. They're not doing it properly. Now, when it comes to vacation pay, probably the best thing that you can do if you're not paid what you're owed is to file a complaint with the government agency in your province, the Ministry of Labor, the Employment Standards Branch, to do it that way. Now, I've said many times on this show, and I'll say this forever, you cannot, should not ever go to the government if you lost your job. They cannot help you. They can only get you a small fraction of what you're actually owed. But when it comes to vacation pay, overtime, absolutely a good place to go to. Yeah, no, this employer is not paying him. They should be paying him, and the Ministry of Labor is the way to go to deal with it.
Got his minimum severance. Now, being on a commission, being a commissioned employee like so many people are out there, how's that calculated? Because commissions, as you know, could do this, right?
So if you're on a commission, salary and commission, so your pay is not the same every month, certainly not every year, but you lost your job, you have to calculate your severance. Well, we simply look at an average. So if you're owed 6 months severance, we'll simply look on average what you earn in a month. We can look at a 3-year average, a 2-year average, whatever is appropriate. And then we say, okay, in a month you earn $6,000, for example. Well, then 6 months severance is 6 times 6, 36, easy to do. So when it comes to your severance, if you're on commission, it's not what you were earning most recently. It's not the lowest amount that you could be earning. It's whatever you would have expected to earn had you continued working. And the way to calculate that is simply looking at an average.
Short break and lots more to go. In the meantime, write down the phone number. Keep it with you. Put it on your phone, 1-855-821-5900 and help@employmentlawyer.ca. More show is on the way. Employment Law Show. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru, reaching out to Lior, the co-founding partner of Samfiru, Tumarkin LLP, the most best widely reviewed, positively reviewed employment law firm in the country. It's easy, 1-855-821-5900. Catch our radio shows as well. It's been almost a decade we've been doing those, pal. We're getting up there, but thousands of phone calls over the last decade across the country with our radio shows. Feel free to call in yourself next time you hear one on air. And I think we're going to get to a third call for today, Lior. Let's get into that.
I've been working at the same company for, it was 17 years when I got laid off last year. Now it's been a whole year, 13 months. Does that get added on to the severance? Like, would I ask for 18 years of severance, or is it 17 years of severance?
It's a common question, right?
It is a very common question. So I'm going to take it a step back first, and by saying that being put on a temporary layoff is in fact a termination, or to put it more accurately, gives you, the employee, the right to treat it as a termination. I know that many of you have been put on a layoff, on a leave because of COVID-19, some of you for many, many months. You have a right, now you could have done it even sooner, to treat that layoff as a termination of your employment. There is no automatic right, doesn't matter what province you're in, to put you on a temporary layoff. By putting you on a layoff, you can accept it. Sure, that's always your right. Or you can choose to treat that as a termination of employment. Now, in terms of length of service, here's how that works. If you are one of those people that decided to stay on the layoff, that's fine. But instead of calling you back, your employer says, well, now we've officially are telling you we're not calling you back to work, we're terminating your employment. Then certainly that year, for example, in this example that you spent on a layoff, counts towards your seniority. So now you're an 18-year employee, not a 17-year employee. By the same way, if you're on a maternity leave and you spend a year on a maternity leave, that year counts towards your seniority. Absolutely. So you may well have more seniority than you realize. But the key which is what I want everyone to take out of this particular question and issue here, is that if you're on a layoff, you can choose to say enough is enough. I don't want to accept it. I don't want to stay home and wonder whether the phone's going to ring. I am choosing to treat this as a termination, get my severance now, and move on. If that's what you want to do, let's talk.
Another place to ask questions anytime. We tell you every week, terminationquestions.com. We'll get to our first one for this show. Lior Mativa writes, says, I'm returning to work after my insurance provider cut off my long-term disability benefits related to a car accident. Not only am I not physically and mentally ready to return, but my employer is nearly doubling my workload. What can I do?
So there's a few issues here. The first issue is the fact that if, in fact, Mativa can't work and her doctor says you still can't work, her insurance company should not cut her off, okay? And this is a very common situation. I know a lot of our viewers have been in that situation where the insurance company says, yeah, you're not injured or sick enough, you can go back to work. Whereas in the meantime, you're saying, I can't, and my doctor agrees with me. So the first thing we could do is deal with her insurance company. Oftentimes, as soon as the insurance company hears from us, they'll say a few curse words because they're not very happy, and then they'll do the right thing, which is to keep the employee on the benefits. So if that's your situation, if that's what you're facing, insurance company's cutting you off, and you've been paying into this plan, and now they don't want to pay you when you're not able to work, let's talk, let us deal with your insurance company. But beyond that, even if you are cleared to come back to work, you may have limitations. Okay, you may need accommodation, you may need modified hours, modified duties, and your doctor is judge and jury when it comes to those restrictions. So all Mativa needs is a doctor's note telling her employer, can she work regular hours? Can she do certain jobs? What kind of help, assistance, and accommodation does she need? And once she has that doctor's note, her employer has to find a way to make it happen. If they don't, that's a human rights violation. It's illegal. That could also be considered a constructive dismissal. So you name it, it's a wrong. So let's deal with your insurance company. Let's keep you on those benefits. And of course, let's also make sure that your employer doesn't overstep its bounds and disagree with your doctor.
Got time for one more really quickly, Lior. We'll get to it. This from Brian, again, terminationquestions.com. Says, a friend of mine who works in HR told me severance pay is 1 week for every year of work for a company. Are there any other factors that go into a severance package?
It's this issue that was the genesis for us doing this show and our radio shows all these many years ago. So no, that's not true at all. Your minimum entitlements may be 1 week for every year of service. Your minimum, that's the key word. Your full entitlements, often called common law entitlements, can be 50 times that. Okay? So let's be very clear here. Your full entitlements, common law entitlements, are calculated based on a number of factors. The main factors are your age, your position, and the length of your employment. The longer you work, the older you are, and the more senior a position you have, the more compensation, the more severance is owed to you. So your minimum entitlements could be 5 weeks. Your common law entitlements could be 12 months. Your minimum entitlements could be 8 weeks. Your full entitlements could be 24 months. I think you get the idea. So bottom line is, this person, Brian's friend in HR, is wrong, absolutely. To find out right now, I've said this before, how much severance you're owed, what your full entitlements, not minimum entitlements. Who cares about the minimum entitlements? Your full entitlements. All you do is you go to pocketemploymentlawyer.ca, use our severance calculator tool there. It's free, it's anonymous. No reason, no excuse not to use it right now.
And that is it for another show. Appreciate you reaching out to Mativa, Mark, Brian, everybody else who called into the radio show or went to terminationquestions.com. You could do that anytime yourself. And the phone call, 1-855-821-5900, help@employmentlawyer.ca. We'll catch you next time on the Employment Law Show. Appreciate it.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.